आइए इन बदलावों को समझते हैं. Welcome to today's explainer. We are completely unpacking the massive and honestly highly anticipated new UK immigration rules for 2026. We've got a ton of ground to cover today, from some really severe tightening of regulations to sudden chaotic political shifts that could literally change everything for migrants. So let's jump right in and break down exactly what these new rules mean for you.
Okay, let's dive into this outline. Today we're going to cover the 2026 immigration bill, stricter family life rules, deportation and asylum changes, some good news, yes, there is some, the political landscape, and finally, future transition rules.
Section 1, the 2026 Immigration Bill, sweeping changes to the legal landscape. So, this new framework was first announced during the King's speech on May 13th, and it has already flown past its second reading. The Home Office is bringing in some serious tightening here. One absolutely crucial and controversial addition is the Independent Immigration Appeals Authority. The plan? To have non-legal, unqualified personnel trained up to make decisions on your immigration appeals, kind of like laymen sitting as magistrates. But here's the big question. How can a tribunal truly be independent if it operates directly inside the Home Office? The potential for bias during their training is a massive point of concern right now. We're also looking at a huge procedural shift. The old Section 120 notice? Gone. It's being replaced by what's called a claim notice. So instead of just sitting back and being processed for removal, you now have to proactively serve this notice to the Home Office, explicitly stating all of your reasons why you shouldn't be removed. Basically, the burden of proof is shifting completely onto the individual. Section 2, stricter family life rules, redefining who counts as family under Article 8. Now, what's really interesting about this is how drastically family life is being redefined under Sections 117A and 117B. In the past, if you'd built a private life here over, say, 10 or 12 years, you could legitimately argue that siblings or even close friends who provided care for you were part of your family life. Not anymore. Under the new strict definition, judges are only going to look at your spouse, your children, and your parents. That's it. Relying on the sibling or a best friend for an Article 8 claim, it's just not going to hold weight with a judge anymore. Think about it like this. If you try to claim dependency on someone outside that super strict core, say your brother who cares for you, you are now facing an unbelievably high bar. You have to prove the dependency goes way, way beyond emotional ties. Financial dependency? Nope, not enough on its own. Even having a basic physical or mental condition won't automatically get you over the line. You essentially have to prove to the court that your condition requires continuous, round-the-clock support that you absolutely could not receive if you were sent back to your home country. And this ties right into the new financial and health tests. Under the old 117B3 rule, you just had to be financially independent and able to integrate into society right now. The new rule? It demands you prove you will not rely on council housing, benefits, or, and this is the kicker, health services in the future. Honestly, this is devastating for elderly migrants or anyone with existing medical conditions. A judge can literally refuse your visa just because they think you might need the NHS down the line. There is also a massive crackdown on unlawful presence. Under the old system, judges were told to give little weight to time spent living in the UK unlawfully. Now, they're instructed to give no weight at all. Zero. Meaning, if you've been living under the radar in the UK for 15 years, that time offers you absolutely zero advantage in court. Plus, cooperating with immigration authorities and proving good character are now strict, unavoidable prerequisites. It completely wipes out the old defense of long-term illegal residence. For any parents watching, please pay close attention to this one. The 7-year child rule has completely transformed. It used to be that if your child had been here for 7 years, you had a pretty solid case that it was unreasonable for them to leave. Well, now you've got to clear 3 incredibly high hurdles. First, prove no education is available for them in your home country. Second, prove they'd face severe hardship and completely fail to integrate. And third, prove relocation would cause long-term negative health impacts. Just speaking English or feeling settled here, it's just not enough anymore. Section 3, deportation and asylum changes. Expanding Home Office powers. Okay, so we're seeing a really severe tightening of deportation rules. Historically, fighting a deportation order often came down to the length of a prison sentence. You know, the difference between a 1 to 4 year sentence versus over 4 years. Those old thresholds are gone. They're being replaced entirely by a threshold of exceptional circumstances. Judges are now going to order deportations based heavily on the negative impact the crime had on society, rather than strictly looking at how long the prison term was. And over in the realm of asylum and humanitarian protection are being squashed together into a single core protection status. But crucially, victims of slavery and trafficking are losing some vital discretionary relief. That previous 2.5-year psychological support visa removed completely. Plus, any late claims are now going to face incredibly strict credibility tests to weed out what the Home Office considers bad faith applications. Section 4, the good news, the July 9th Statement of Changes. Let's move to and see how this builds into some much-needed relief. I know we've covered some really heavy stuff, but these July 9th updates actually offer some solid positive steps. This is a game changer for anyone currently stuck waiting on an admin review. Under the new 14-day rule, if your 3C leave and subsequent admin review are refused and you get placed on immigration bail, you aren't immediately dead in the water. You get a 14-day window to submit a completely new application. So you could switch to a skilled worker visa, for example. You do remain an overstay without work rights while it's pending, but it totally saves you from dropping into strict illegal status. Oh, and here's another fantastic update. The Home Office finally fixed Rule 9.4a. There used to be this awful gap leaving newborns in legal limbo, but now babies born in the UK to parents holding a graduate visa will automatically be granted visas in line with their parents. Just a simple, logical fix that's going to be a huge sigh of relief for new families. Section 5, the political landscape. Leadership changes impacting immigration policy. Now, the timeline we're about to look at is, well, chaotic to say the least. Remember, we're just neutrally reporting the facts here to help you make sense of this wild ride. So, late June 2026. June 22nd, Keir Starmer announces his resignation. The very next day, a House of Lords committee drops a highly critical report on the government's immigration plans, strongly warning against increasing the ILR qualifying period from 5 years to 10 years for lower-income families. And then, by June 25th, Immigration Minister Mike Tapp comes out and suggests care workers should be exempt from that 10-year rule entirely. This quote really hits the nail on the head for the House of Lords stance. They pushed back extremely hard against making rules retrospective for people already living in the UK. They also argued that granting faster settlement just because someone earns a high salary is completely arbitrary. They suggested focusing on fiscal contribution instead, like the crucial work done in the care sector. Their recommendation? If you're going to grant ILR, just restrict access to benefits rather than pushing back the settlement status itself. So the crucial point is how unbelievably fast the narrative shifted in July. On July 7th, Shabana Mahmood is taking a super hardline stance, but less than a week later, the Times leaks that transition rules might actually happen. This immediately gets Conservative leader Kemi Badenoch expressing concern over migrants getting transition benefits. And then bam, July 17th, the whole landscape shifts again when Andy Burnham is announced as the new Labour leader. Before Burnham took over, this was Shabana Mahmood's explicit stance. She firmly believed the government needed the power to change rules retroactively, even throwing out the idea of using military bases for asylum seekers. But with Andy Burnham now at the helm, the rumor mill is spinning that Mahmood might be promoted to Chancellor. If she's removed from the Home Office entirely, we could see a drastic shift in where these policies are heading.
Section 6, Future Transition Rules. What to expect under Andy Burnham.
So what does Andy Burnham's leadership actually mean for you? Well, based on his center-left platform, which is all about stopping infighting, giving power back to local councils, and explicitly not mimicking right-wing policies, sources say there is now a very high possibility of transition rules. Now, the main 2026 bill will likely survive, but migrants who arrived after 2021 might get some protections. The catch? Those protections will probably come with heavy strings attached, like a 10 to 15-year ban on accessing public funds or getting full nationality. Which leaves us with this final massive question. Will Andy Burnham's incoming cabinet actually step up and protect existing migrants with transition rules? Or will the strict mandates of the 2026 bill rewrite everyone's future entirely? This landscape is literally shifting by the day. Thank you so much for joining me for today's Explainer. Make sure you stay informed, keep an eye on these developments, and let me know, where do you think this is all heading?